Hi, I'm Dr. Mark Studin, and first I'd like to thank I'd like to thank ChiroSecure the opportunity for giving me the platform to share this information with you. Today we're going to talk about personal injury lawyers, and not will they work with you, but can they work with you? And we're going to go to the slides now, and I'm going to explain the entire thing to you best I can in the time that's allotted. So the question is, oh, by the way, a little bit of housekeeping. I'm a little bit of a nerd. I'm working on 4 screens. I'm going to be reading off a screen this way and then looking at you this way, so I apologize for this side of my head. So the question is, it's can they work with you, will they work with you, and why? So my initial paradigm was my wife, actually, who had cancer 3 times, 2008, 10, and 11. She had kidney cancer. She's great. She's had multiple surgeries. But originally, when we started, I had to find a cancer surgeon. And I found the right guy. We live in New York, so I went from Boston to New York to Philly to Washington. And if you can't find the right doctor in that corridor, you're in trouble. I found the right guy in Columbia Presbyterian Hospital, and I called to get an appointment, and they said, 6 months. I said, 6 months? Are you crazy? She'll be dead by then. I'm sorry, the doctor's busy. He gets patients from Europe and Africa and South America. There's only 2 hands. Well, I don't take no for an answer. So I called everyone I know, senators, assemblymen, congressmen, other department chairmen. It took me 3 weeks. I got her an appointment. And the moral of the story is she's doing great. It was the right doctor. And going through that process, she needed a hematologist. She had a complication. She needed this. She needed that. And it was the same thing to get the best of the best. To get an appointment was challenging. And going through that process for 5 years, I said to myself, why do patients not run after chiropractors the same way I ran after those cancer surgeons? Well, you know what? Yeah, they deal with more life and death than we do. But if your patient can't function and they don't have a life, then their life is upside down, and they need you as much as I needed that cancer surgeon. So that's all nonsense. So I've spent the last 11 years trying to figure out how to get your referral sources to run after you. And we actually cracked the code. But then we have another issue. The other issue is lawyers have to get past hurdles in order to get cases to trial or significant settlements. And that's taking me a little over, I think it's been 13 months now. And we finally figured out the reason why. And let's just look at a graph. This was the last 13 months, but I started before that. And I used my medical school academia, because I'm a clinical instructor at the graduate medical level for the State University of New York at Buffalo, Jacobs School of Medicine and Biomedical Sciences, for multiple courses. And I was able to use that hat in communicating with multiple different attorneys and medical doctors, surgeons, neurosurgeons, pain management doctors, to determine why people work with us and not, and why. And the question is, here's the relationship to the lawyer. First, I thought we were a risk to the lawyer, and they don't want to work with us. But then it changed. We've become a liability to the lawyer based upon rules of the courts. So you're either a risk and liability or the lawyer's secret weapon if you can get past 3 specific hurdles. And I'm not going to really talk about those hurdles other than to mention them. Number 1 is pre-existing issues, 2 is strain sprain, and 3rd is low speed impact crashes. So those are lawyers' hurdles before they can even get to you. But we'll talk about that at a different time. So we're going to delve into a good narrative versus a bad narrative. We're going to talk about Colossus reporting, using that Colossus paradigm to get the lawyers to want to refer to you. We're going to talk about X-ray digitizing, and that's supposed to say AOMSI, not just OMSI, it's a typo. Using that is the reason for the lawyers to work with you. And then your credentials as a doctor of chiropractic, which, by the way, are incredible, but not enough. Then we're going to talk about demonstrative reporting and chiropractic and MD credentials. And those things are critically important to understand. Critically, all of them. So, and that's when you morph over from a risk and a liability to the lawyer's secret weapon. So let's start with narratives. Now, as good as a narrative as you have, Even the best of chiropractic narratives are considered a liability to the lawyers unless there is an invasive surgical procedure to piggyback that report. See, they're using you for continuum of care, just like the physical therapist. You've been relegated down to that level because they really have a challenging time using your words. They just do. Now, your report will be considered additional functional losses as well to that surgery. That's why lawyers are strongly pushing for surgical consultations in every single case. Now watch. Here's the paradigm for the lawyer. You ready? Here's their mantra. Ortho, neuro, neurosurge. Ortho, neuro. It's a song. They sing it. It's in their head. And there is a reason for that. And I'm going to get to those reasons in just a little bit. Well, the reason is because the ortho, neuro, and neurosurge, if it's non-surgical, 23 years ago, the insurance companies tweaked their algorithms, and actually Computer Science Corporation out of Southern California did it. They tweaked their algorithms so that they paid the orthos, neurosurgeons a little bit more so that they don't go to you. And we'll talk about that in a minute. Concurrently, these doctors, and by the way, you have certain doctors who believe that medical validation is critically important in every single case. I want an ortho, neuro, neurosurge, pain management, physiatrist, even a GP. I want medical validation in every case. Well, guess what? Those doctors are being profiled by the carriers who are aggregating statistics over time and sweeping up all of the players in the scheme where most referrals are circumspect clinically. Why are you referring that patient to the ortho, neuro, neurosurge? Is there a clinical reason? Do you have a herniated disc that's abutting or compressing the cord? Do you have significant motor loss? Do you have a foot drop? Do you have significant paresthesia? Why would you refer that patient out? Is there a myelopathic finding? Do you know the difference between radiculopathy and myelopathy? If you don't, go back to school. You have to know that, even if you take care of only Medicare patients. But is there a significant myelopathic finding? Is there myelomalacia or cord edema? All of these different things. Are you looking at a syrinx? And do you have a syrinx in the lower lumbar spine? Which is a trick question, by the way. You have to know all of those things to determine if it's appropriate to make that referral. Because if you're just referring because it's a trauma case, it's personal injury, well, that looks like you're colluding with the lawyers in order to make the case more valuable and more money, so the lawyer likes you better, so they'll refer more cases to you. And that's ungood. That's where Mr. Rico can come knocking on your door. RICO is under the Organized Racketeering Act in federal courts where the insurance companies really are using the power of computers to really ferret out those who are doing things inappropriately. Then there's those that created the Colossus busting reports. And they've been espousing this for 10 years. Every couple of years, there is always a get-rich-quick scheme in our industry. Colossus was one of those. And by the way, it's real. And for those of you who don't know what Colossus is, it was created in the 1980s by the government of Australia who wanted to create a dollar value on injured workers who were going out permanently on disability. Allstate in the 1980s realized there were too many claims rep making financial decisions and not enough automation. So they went to Australia, they loved it, they bought it, they came back to the States and called it Colossus. Today there's 80 to 90 different programs like Colossus. State Farm calls theirs Teach. Everyone calls it something different, but for this conversation, we'll call it Colossus. It's real, and lawyers don't care. Colossus busting reports will get you 0 referrals, but they will get you unwanted additional scrutiny because the carriers are looking at your 68 diagnoses, your medical validations. I can go right down the list. I know them all. Although duties under duress and loss of enjoyment of life, although are important in a case, will not get you additional referrals. I promise you. I've surveyed over 10,000 recently lectured to attorneys. And by the way, I've lectured to probably close to 400,000 lawyers in 39 states. And although trained in impairment rating, they have to have impairment ratings. And most medical doctors are not qualified to render an impairment rating. It's within their license, but they're not qualified. And you need, of course, an impairment rating. So I just recently sat with a group of attorneys in New Jersey who I've lectured to at least 10 times each of them of the importance of an impairment rating in their case, which can be worth upwards of 75% of the settlement value. 10 years later, guess how many are using it? Zero. Nada, zilch, gunish, niet, whatever language you want. Not one, because they don't get it. They don't get it. And as a result of not getting it, they're not using it. And if you talk to them, oh, I have Colossus reports, they don't care. You're falling on deaf ears. It will not get you a case. And when they see all of these inflammatory diagnoses, and I'm not saying they're not necessary, it might be necessary, it might not, but you're an outlier, and it gets them nervous, and they think you're a liability. And when they see on every single case, the same MDs referred to, they're concerned that they're going to go down, and you're a liability. They're not going to want to work with you. And listen, I'm in Florida tonight. I was in New Jersey last week. I'm going to be in Nebraska in a few weeks, and I'm in Texas, California, Colorado. I go all around the country. It's no different. It's just no different. Let's talk about X-ray digitizing and AOMSI. At least they got the typo right in the red. If this is the core of your argument to lawyers to work with you, forget about it. Just forget about it. I am an owner of Simverta. It is an X-ray digitizing platform and possibly the best in the industry. Hey, I could say that, it's mine. But unless you have the ability to document all bodily injuries demonstratively, lawyers will be intrigued with the 25% or whatever it is, whole person impairment, but will not consider shifting their referral patterns to you. It's ortho-neuro-neurosurge, ortho-neuro-neurosurge, bypassing you. I get calls every day from doctors. Hey, I'm using your platform. How come I'm not getting all these referrals? I said, because I never promised you would. And if you're using X-ray digitizing, you need additional credentials in spinal biomechanical engineering. It's just the way it is. You have to have the credentials or you won't pass voir dire. You won't pass an expert hearing. And that's critically important. Now, with that being said, sorry, I was just looking for something. With that being said, it's important and it helps with demonstrability. It helps tremendously. I mean, we had a case in New Jersey, it was in Clark, New Jersey, 4 weeks ago, where the lawyer went from $10,000 to $90,000 in settlement only using Simverta technology. It could also age date. Simverta has the ability to age date pathology, which we're not going to get into today. So there's a lot of really good things going on with X-ray digitizing. There's a lot of great things going on with it. It's wonderful. But if that's the core of your argument to get them to shift their referral pattern to you, it's not going to happen. I don't think so. I know so. I've been with the attorneys much. Too many of them and too many other doctors I work with say it's just not enough. When you have all the other things, this is an incredibly important tool that you need. You need X-ray digitizing, need with a capital N. But if that's the core of what you do, and that's your argument, let me say this again. Here we go. Lawyers will be intrigued with the whole person impairment, but will not consider shifting their referral patterns to you. It's not enough of the puzzle for them, and they will still work predominantly with their ortho-neuro-neurosurge, and they go on and on and on. Now let's talk about your chiropractic credentials. The insurance industry hires people to template responses to the attorneys. I know because I've lectured inside the insurance industry in my career extensively. Here it is. You ready? You only have a chiropractor? With the inflection, by the way. That's how they're trained. You only have a chiropractor? That's what they're telling the attorneys. They don't want to work with you. You know when I heard that last? 10 minutes before I went online. I spoke to one of the largest law firms of the East Coast. And they say, but you're only chiropractors. And I've heard that from every carrier. You're only a chiropractor. Listen, I love chiropractic. And think that is all you should need. However, there is a definitive prejudice within the court systems slanted against doctors of chiropractic. Multiple recent motions in limine, which we're going to talk about a lot in a few minutes. That's a court motion to preclude chiropractors from testifying on anything other than what their hands touch. They're attempting to limit chiropractors on MRI finding results, causality, ligamentous injuries, permanencies. They only want you to do what your hands touch. There's a tremendous prejudice against chiropractic. And if your only credential, and a credential is not just a DC after your name, a credential is all the courses that you post on your curriculum vitae. And your curriculum vitae is your current business card. Make no bones about it. Your curriculum vitae is what you should work on every single day to build and make stronger. Demonstrative reporting is critical. Now, that's when you're starting to become the lawyer's secret weapon. We have devised a way to report. I've devised a way to report the majority of spinal-related bodily injuries demonstratively and pain. This has never been done before in our industry, inclusive of medical specialists. When I first revealed this a little over a year and a half ago, I had a Harvard-trained neuroradiologist look at it and say, "Holy crap, where'd you figure that out? Who told you this?" I said, "No one, I just figured it out." And that's what's needed, because I study intensively what the needs of the courts are in order for attorneys to prevail. I look extensively what the needs of surgeons are to better understand the pathology. And they're now learning from chiropractors. He said to me, "Mark, they didn't train us on that in Harvard. I wish they did. But even if they did, I wouldn't have the time to do it." So here's and by the way, this is not something you could learn in a weekend course. You need real credentials behind you on interpreting MRI, on understanding connective tissue pathology, which is strain sprain at a significant level, the evidence behind it, how to interpret it, how to be able to show it, and how to use certain computer programs to interface with the MRI images that you're looking at. Then you need to be able to do things such as clinically correlate the but-for causality, which I don't have time to explain, demonstrative bodily injury, which I'm talking about right now, and then persistent functional loss, just as Colossus explained it, with duties under duress and loss of enjoyment of life, while you're handling the pre-existing issues and ruling out pre-existing issues, or ruling in if you're timing it, because there are 14 physiologically valid ways to age date pathology, specifically with disc. There are 14 ways to do that. You have to be able to look at arthritises, which is arthropathies. It's not arthritis. It's an arthropathy pathology of the joint. It's not an inflammation. You have to be able to look at all of these things and clinically correlate them. In the last year, we've got, and I'm going to show you some stats in a moment. I'll just pop over. Here we go. You ready? Settlements have increased across the country by 1,076%. Verdicts by 3,526%, and non-herniation settlements by 776%. If the lawyers prevail ethically, you succeed with referrals that will be hard-pressed to stop for the balance of your career. You're going to be hard-pressed for them to not refer to you. This is real, folks. This is real. These are your settlements. Alabama, California, Colorado, Connecticut, Georgia, Kentucky, Massachusetts, New Jersey, New York, Oklahoma, Pennsylvania, Texas, Virginia. This is preliminary. We've just started acquiring these statistics, 1,076%. In verdicts, you ready? This is just easy. 3,526%. Takes a little bit more time to get verdicts out of the way because we just started doing this work within a few months and they haven't all gone to court yet. But it just works easy. And in the burnt orange, those are the ones where we've just used Simverta for connective tissue strain sprain onlys, and that's the settlements we're getting. I mean, $25,000 to $495, no MRI. I mean, $25,000 to $1.25, no MRI. $5,000 to $90. I didn't put the $10,000 to $90 up, and I could go on and on and on around the country. So it's working. Once you remove the deceptive rhetoric and replace that with demonstrability, to verify, and not just the bodily injury, but pain as well. And we're making demonstrable things like herniated disc, spinal cord involvement with myelomalacia or cord edema, fecal sac involvement, the disc itself showing where the pathology is. We're looking at nerve root abutment. We're looking at chemical radiculitis. All of these things can be seen and have to be shown and drawn up in a very specific pattern so that a junior high school kid understands it. Then we look at credentials. Look, I love chiropractic. I said that before. But in the aforementioned motion in limine, being cross-credentialed through chiropractic and medical academia is the arbiter between being accepted as an expert or not. A motion in limine is a motion that a defense lawyer brings in a case like this to prevent you, the chiropractor, from testifying. Now, you have to get through something called voir dire or Daubert or Frye or Schreck, depending upon your state. All of those are standards within the states which a doctor has to go through a credentialing process where a judge can rule, yes, you're an expert, or no, you're out of here. The motion in limine is to try to get you out of here before you can even have that hearing. And we're starting to see them all across the country. Now, by the way, that equates to lawyers working with you or not. If they can't work with you because you don't have any credentials, or the courts rule you're not an expert, they're never going to work with you. And that's public record. So there's no secret society where too often political cronyism gets you into networks. How do I get these credentials? How do I do all of this? How do I become an expert? In certain circles in our industry historically, unless you're involved in this organization, with a secret handshake, you can't get into this network. That happened to me for almost 20 years of my 42 years in the profession in New York. Unless you're a board member of this state organization, you can't be in this network. I mean, it eviscerated my practice and many others. Guess what? Anybody can do that. Any willing provider can take courses and get credentials at teachdoctors.com. Go take courses. Why that particular program? Because you get credentialed both in chiropractic and medical academia. And that's important. And the more credentials you have, and again, a CV citation is the credential, the stronger your practice, and you will get more referrals if you know how to position your practice. That's something I can help you. If you give me a call, it'll be my pleasure to share with you. So a doctor of chiropractic as an expert can be a risk of liability or your secret weapon. These are different credentials doctors can get. MRI interpretation, trauma qualified, interprofessional hospital, evaluation and management. Every one of these qualifications are recognized through Cleveland University College of Chiropractic, but every course in here is recognized through the State University of New York at Buffalo Jacobs School of Medicine. If you take all of these courses, you can be conferred a fellow in primary spine care, certified by and enjoying providership with State University of New York, SUNY, SUNY Buffalo Medical School, and Cleveland. So you can have a medical school certify you as a fellow. And then after your DC, you get FPSC, Fellowship in Primary Spine Care. If you have that, you become bulletproof to what they call motion in limines. And that's a biggie. And we're starting to see this around the nation. I'd like to take a moment and do something that I really hate to do while I lecture, and that's read. But I want to read an article to you that I just wrote yesterday, and I wrote this to my consulting clients, and I want to share it with you. But it's something you need to understand. State Farm has spoken. Allstate has spoken. Over and over and over. You must listen and act before it's too late for you if you want to have a personal injury practice. Oh, where'd that go? Wow, that's bizarre. Okay, let's do that again, and let's do this. Wow, it's going blank. Okay, so we're going to show it in a different format. It's going to be a little smaller. Just bear with me. I'm going to read. Trends in any industry give insight into the future, and it's often an accurate crystal ball that enables you to prepare for the future, whether it's near or far. Ignoring trends in any industry is typically the death knell of anyone, and giants like Sears, Toys R Us, Pier 1, Ringling Brothers, Lehman Brothers, Sports Authority, and others have ignored future trends in their industry. They held on too long to failed business strategies, which cost them billions and put them out of business. The chiropractic industry is no different. Over the past 2 decades, I've sought trends in our industry to help you prepare for the future. Often that came from stitching together disparate pieces of information, looking at subtleties, and sometimes just reading the tea leaves. Today, however, there are no subtleties. State Farm and Allstate have clearly stated what the future of personal injury is for a chiropractor. They are being hurt financially by you and using the courts to end it. And when I say by you, it's those credentialed doctors who have the credentials I shared with you a moment ago. In the past, the carriers used federal RICO cases and other instruments to sue chiropractors after the fact, actually to get their money back. Today, the carriers have added motions in limine to prevent their system of deceptive rhetoric from collapsing. A motion in limine is a pretrial motion asking that certain evidence or experts be found inadmissible whose opinion is not considered at trial. In this case and others, the goal is to invalidate the chiropractor as an expert and prevent your testimony from being admitted. In short, to make you non-existent in the courts and alert lawyers not to work with you in the future. I've now seen the same language 6 times, confirming a trend and a standard of practice by State Farm, Allstate, and other carriers. The following is a California case, but don't be fooled by California. It's the same language nationally. I'm just going to read the heading. John Smith, a chiropractor, lacks the qualifications to interpret radiological studies, to diagnose a permanent ligament injury, and to render a medical opinion on injury causation, which is all absurd. However, that's their motion. The doctor defending this motion now realizes that he achieved what he wanted with our programs and personal injury. The carriers fear what he has to offer to a case and now consider him a long-term threat. By the way, that motion was overcome, and that case went from, I think, a $50,000 offer to a $3.5 million verdict. That's what the carriers are trying to prevent. The carriers are in a no-lose area. If they succeed, they knock this doctor out and most DCs out of the personal injury game, perhaps forever, because it's public record. This doctor will forever be associated with this motion and not permitted to opine in other medical legal cases. But if the carrier loses, they still succeed because they've set the standard for every other DC to opine. And that is everyone other than the trained doctors. So if you have those credentials that are co-credentialed through chiropractic and medical academia, you're one of those trained doctors. And every other chiropractor in the nation just became irrelevant. You just made your competition irrelevant. The upside for this doctor and all others in this situation stand to have their practices skyrocket if they prevail. Again, this is a public record, and they can share this with every potential referrer in the region. Once lawyers realize the courts have verified you as an expert, it makes the entire process of referring seamless. The doctor in Georgia, Dr. Capaferri, has already defended and prevailed 5 of these court proceedings with similar language because he was prepared. He listened and did everything I told him well in advance, and I shared with him, as I share with all of you, you need to be prepared in advance if you want to succeed over the long haul in personal injury. And it doesn't matter what state you're in. Unfortunately, the doctor in California, that particular doctor in California, did not heed the advice and only completed a trauma qualification and a few other courses. He actually went and then finished the MRI interpretation and primary spine care, and he did prevail as a result of that. So this is a little old. I'm confident the doctor will hear it. He prevailed. But if he had listened, it would be a slam dunk. Where do you fall in the process of credentials? Please don't have me say I told you so after the fact. It is gambling with your career when you're now in full control of your potential skyrocketing success. If you plan to succeed in personal injury, You need to be bulletproof when the carriers are already doing. You need to be trauma qualified, MRI qualified, and primary spine care qualified. This is about 250 hours of education, which is more than halfway there towards being a fellow in primary spine care. And again, you get them at teachdoctors.com if you'd like. All courses are credentialed through chiropractic and medical academia, which resolves most complaints from the carriers. Folks, listen, I could talk about this for hours, but I am telling you, here's your caveat emptor, buyer beware. They're coming. They're going to come get you. It's just a matter of time. If you want to be taken seriously as an expert in personal injury, and listen, personal injury is the last best place to earn an incredible living within our profession. And I see nothing wrong with treating personal injury cases. I love trauma care. But you've got to be qualified. It's within your license, but are you qualified? Are you expert? Can you interpret an MRI? That historically has a 43.6% error rate from general radiologists. You need to be insulated from those things. You've got to be the real deal. Folks, listen, I'd like to thank you so much for sharing your time with me. Again, I'd like to thank ChiroSecure for the opportunity to share my message on a periodic basis. It's an honor and a privilege, and I just really, really, really appreciate having the opportunity to share my knowledge with you. I'd like to thank you all, and I look forward to seeing you on the next show that I've got. And next week, look for ChiroSecure's other shows that they've got. They're just incredible. Thank you. We'll catch you next time.